Provision of Gujarat anti-conversion law that High Court has stayed for now. The new anti-conversion law shifts the burden of proof of a lawful religious conversion from the converted to his or her. The Gujarat High Court this week stayed key provisions of the Gujarat Freedom of Religion Amendment Act 2021 pertaining to marriages involving religious conversion of either of the two parties. While a larger constitutional challenge is still pending, the interim stay provides relief to interfaith couples. What is the law under challenge and how does the High Court order impact it? What is the law under challenge? The law under challenge is the Gujarat Freedom of Religion Act 2021. The legislation amended the 2003 Gujarat Freedom of Religion Act. The amendment was brought in line with several similar laws enacted last year by BJP-ruled states, starting with Uttar Pradesh. The law ostensibly seeks to end conversion through unlawful means, specifically prohibit any conversion for marriage even if it is with the consent of the individual except when prior sanction is obtained from the state. Apart from UP and Gujarat, Madhya Pradesh and Himachal Pradesh too have also enacted similar laws. Why have the laws been criticized? The new anti-conversion law shifts the burden of proof of a lawful religious conversion from the converted to his or her partner, define allurement for religious conversion in vague, over broad terms, prescribe different jail terms based on gender and legitimate an intrusion of family and the society at large to oppose interfaith marriages. They also give powers to the state to conduct a police inquiry to verify the intentions of the parties to convert for the purpose of marriage. Legal experts have pointed out that laws interfere in an individual's agency to marry a partner from a different faith and to choose to convert from one's religion for that purpose. Apart from being vague and sweeping, the laws also test the limits to which the state can interfere in the personal affairs of individuals. The freedom to propagate one's religion and the right to choose a partner are fundamental rights that our new anti-conversion laws impinge upon. What has the Gujarat High Court held? A division bench of the Gujarat High Court comprising Chief Justice Vikram Nath and Justice Viren Vaishnav have granted an interim stay on certain provisions of the amendment that interfere with the interfaith marriages. Prima facie interfaith marriages between two consenting adults by operation of provision of Section 3 of the 2003 Act interferes with the intricacies of marriage, including the right to the choice of an individual, thereby infringing Article 21 of the Constitution of India, the High Court order says. The other provision state includes Section 6A that reverses the burden of proof of the partner of the converted spouse to prove that he or she not coerced the other spouse, Section 4, which allows the aggrieved person, their parents, brother, sister, or any other person related by blood, marriage, or adoption to file an FIR challenging the conversion and subsequent marriage. However, this reading of the High Court will be subject to its final decision as the remaining provisions of the law are yet to be examined. The interim stay on certain provisions will have to be confirmed when the larger challenge is decided. Why has the High Court stayed the provision? The submission of Mr. Trivedi, learned Advocate General, that the element of fraud, allurement or coercion which is sought to be brought in by reading the statement of objects and reasons and other provisions of the 2003 Act may not be understood by a common man. The interpretation of Section 3 of the 2003 Act, as Mr. Trivedi, learned Advocate General, wants us to read would be subject matter of education, but prima facie on a plain reading of Section 3 of the 2003 Act, we feel that marriage interfaith followed by conversion would amount to an offence under 2003 Act. Marriage itself and consequential conversion deemed to as an unlawful conversion attracting penal provisions, the order of the High Court said. From the perception of a common man, it appears that merely because of conversion occurs because of marriage, it per se cannot be held to an unlawful conversion or a marriage done for the purpose of unlawful conversion. What was the government's defense? The state government had argued that the law did not prohibit all interfaith marriages, but only the ones based on fraud and coercion. To buttress its submission, Advocate General Kamal Trivedi had argued that the Act must be read as a whole to interpret the provision, and the provision alone could not be read by itself. However, the court said the wider interpretation would happen at a later stage and stated the provisions for the time being. A larger challenge would determine the fate of the law eventually. What is the impact of the ruling? The High Court ruling, although preliminary, comes as a relief to interfaith couples from being harassed. The reading could have a bearing on challenges pending in other high courts. However, its real impact on the ground could be limited, as larger constitutional nuances are often difficult to permeate, especially when it is not a final and binding verdict. Thank you.